Welcome back to our podcast ABNR. Today, we're diving into a crucial topic here, real estate law in Indonesia. Whether you're a property investor, a developer, or just a curious person about legal landscape of land ownership and transactions, understanding the rules and also regulations, I think it is vital. So we'll explore more about the key aspects of property rights, foreign ownership, and also recent legal developments that shape our real estate market here in Indonesia. And we're very grateful to have a very special guest today. We have Edgar as our foreign counsel, and we also have Bang Dani as our senior associate, as well as Zefanya as our associate here at ABNR. Now, before we start, I think we can start by introducing ourselves to our listeners of Podcast ABNR. Maybe Edgar, you can start first.
Hi, I'm Edgar from Korea. I came to Indonesia in 2014. I'm very pleased that I can talk about the real property field today among many other fields, as real property issue is one of the most distinctive and unique features in Indonesia in comparison with many other jurisdictions.
Thank you, Edgar. Maybe Bang Dani would like to introduce yourself as well.
Hi listeners, my name is Tanuwijaya. I am a senior associate in ABNR and have been working here for more than 10 years. Currently, my current focus is on the real estate as well as on the project finance.
Okay, thank you so much, Bang Dani. And maybe Mbak Zay?
Hi, my name is Zefanya. You can call me Zay. I'm an associate at ABNR since 2023, currently focusing in real estate and with over 9 years of experience, both in law firms and in-house roles.
Thank you so much, everyone. Let's talk about the background before we delve into this conversation. Now, as we may know, there are many types of land transactions. Could you please briefly introduce the main types of land transactions first to the audience?
Sure, there are many types of transactions regarding the land and generally can be divided into whether you would like to acquire the land title or you would like to just utilize the land for a certain period of time. Like for example, if you would like to acquire some sort of land title so that you would like to have the assets in the form of the immovable assets of land, then you would be undergone through the sale purchase, or you would also be able to acquire the land through the method called the land relinquishment. However, if you would like to just use the land for a certain period of time, the most common land transactions that can be used in practice is the lease agreement, as well as other types of transaction.
So for the second type is the utilization of land. There are two schemes here. The first one is the lease agreement, and the second one is land utilization agreement. Although it's quite similar, lease agreement grant the lessee right to utilize a specific land for a specific period as well in exchange for rent. And the second one, the land utilization agreement, it also grants utilization rights, but is typically for a specific purpose and is granted over the other land title. So there are two types here, right of ownership or hak milik, and right to manage or hak pengelolaan. And then this right to manage is the type of right that is granted to government agencies or state-owned enterprises, and it's the typical of the land title is to manage land for designated purposes while allowing third-party use. And unlike a lease, this land utilization agreement scheme, it may involve profit sharing or other forms of compensation, so it's different from a fixed rent.
Thank you, Mbaze, for the explanation. The two things that I'd like to discuss more, I think Bang Dani has mentioned previously, I think it's about sell and purchase of land and also relinquishment of land rights. Can you tell us a bit more about those two?
Sure, Reza, thank you. With regard to the sale and purchase of land, you can say it is a direct transfer of the land title from the seller to the purchaser, and the document that is going to be signed by the parties is called the deed of sale purchase, or in bahasa akta jual beli or AJB. In this kind of transaction, we need to make sure that the purchaser is eligible to hold the land title that is becoming the object of the transaction. As we know, in Indonesia, there are several types of land title, like for example, the right of ownership or hak milik, and the right to build or the hak guna bangunan. And not all kinds of entities is able to or eligible to hold all of these types of land title. Like for example, a company established in Indonesia is not eligible to hold the right of ownership. And if the land taxation object is the right of ownership, then the company established in Indonesia could not directly purchase such land title. And that's why it becomes a second kind of the transaction that is called the relinquishment of land rights, in which in this scheme, what we are going to do is to relinquish the title to the state, and then the company, as the one who will purchase the land or utilize the land, will pay some sort of compensation and be granted with a priority right to apply for a new land title, such as the hak guna bangunan, the right to build upon the land that it paid the compensation. And in the relinquishment of land rights, the document that is going to be executed is called the deed of relinquishment of right, or in bahasa words, akta pelepasan hak.
See, so it's very different between the two, yeah, Bang, yeah. I'm also curious to know, what are the typical types of problems that you often encounter within your daily task, for instance, in real estate law?
So I think the most common issues with relatively straightforward mitigation would include two things. First one is requirement for a change in land title or downgrading. So usually this happens when the potential purchaser is not eligible to purchase a certain type of land title, like previously Bang Dani explained. Limited liability companies cannot hold right of ownership or hak milik, and so it has to be downgraded to a type of land title that is allowed to be held by the entity.
Aside from what Zay has explained, there are also other complexity that we face when we are dealing with the real estate transaction. In instance, when in our due diligence we found out that the landowner, the registered landowner, is already passed away, then we need to proceed with the inheritance to the heirs of such registered landowners. And this issue, in practice, many problems may arise with regard to this issue. Like for example, how to identify the heirs that is eligible to hold the land title. And in practice, there might be a situation where the registered landowners have more than one wife, for example, and it will cause the complexity to become even higher. And other than that, we also face the situation where the documents is not complete or missing. Like for example, the evidence of ownership is missing, or the documents pertaining to the acquisition of the land, the past acquisition when the landowner obtained the land title. And in our due diligence, we need to analyze each issue that we found, and we need to provide the mitigation to our client in order to safeguard our client when they're deciding to proceed with the transaction.
Thank you so much, Meze, as well as Bang Dani, for sharing the problems that are often encountered doing this transaction. How do you avoid the problems that you often see?
Well, there is no workable solution for every problem. What we need to do, it is very essential to conduct the land due diligence toward the land title or the litigation aspect, whether there's any litigation involving the land, as well as towards the zoning or the spatial plan that is applicable to that area. And we also need to check whether the land is involved in any encumbrance. There's just some examples on the due diligence that need to be conducted. By conducting the due diligence, then the purchaser, showing that he is the purchaser that is acting in good faith because he is conducting the proper checking toward the land before he purchases it.
So to add to that, we can also conduct verification such as land searches, spatial plan checks, and dispute checks as well. So these steps is crucial to verify ownership, to identify whether there are encumbrances, disputes involved with the particular land plot of land, and we can also ensure the intended use aligns with the local zoning regulations.
Okay, thank you so much. Now, Maybe Edgar, can you tell us how do you work as a foreign lawyer here in Indonesia in land-related fields?
Yes. As a foreign lawyer, I don't advise directly regarding Indonesian law without Indonesian lawyers' involvement. Instead, I focus on how we deliver or effectively communicate with the foreign clients, mainly because Indonesian laws and regulations are quite unique and different. And particularly those practical implementation is different with a number of modern countries nowadays. So if Indonesian laws and regulations are explained to foreign lawyers or clients in their home countries just as they are, it can be very difficult for them to understand and fully grasp the nuances. Since many clients are only familiar with their home country mostly, so I need to connect the gap between their understanding and the actual status in Indonesia. So my role is, again, to bridge the gap and smooth the communication process.
Edgar, you've mentioned the Indonesian law is quite unique than others. But what is so different about it, in your opinion?
The practice of law here is highly distinctive. I believe this stems from Indonesia's unique characteristics. While Indonesia has been rapidly modernizing, it takes significant time to implement these changes across the entire archipelago, from Sabang to Merauke. And this includes the development of modern infrastructure, shifts in mindset, and economic growth. One of the clearest examples is ADA law. To understand the legal nature of this concept, it's essential to grasp the geographical and historical context of Indonesia. So ADA law reflects, I think, Indonesia's deep cultural diversity and a long-standing traditions, which makes itself very different from foreign countries.
Thank you, Edgar. I understand your point, specifically when you mention adat land as well. But what are the examples that you have in mind?
For instance, even though Indonesia recently adopted an electronic registration system for real property transactions, updating millions of pre-existing land rights in the land office system within a short period and without errors are significantly challenging. We have seen a lot of issues such as discrepancies in data, delays in processing, and difficulties in assessing updated records. So the e-registration system can enhance, secure the transparency and address common issues such as information asymmetry. However, the system must be implemented very effectively across the entire nation without further delays.
Okay, now that's a very interesting point that you've got. If so, could you please explain how Korea, on the other hand, adopted this e-registration that you've mentioned earlier?
Korea adopted this electronic system for real property in 1994, so it has been roughly 3 decades. And it is generally recognized that the country successfully adopted all these records by around 2002. So it took roughly a decade. Well, given the size gap between the Indonesia and Korea, Indonesia may take a little longer. However, now we have much better infrastructure for internet and the others. So we basically think that Indonesia will be able to catch up all this within a decade too.
So it's comforting to know that Korea also took a significant amount of time for that. Now, could you explain to us if Korea has also now fully updated all of its data in the electronic system?
While the majority of the records were successfully transitioned without significant issues, there are some exceptions though. Many investors from Korea, particularly those from Seoul or other cities, tend to assume that Korea's e-registration system completely covers every piece of land without any problems. However, actually that is not true. For example, my parents own land in Korea. It's in a rural area, and that isn't formally certified. Remarkably, this land is still registered under the name of Japanese individual from a century ago.
Yeah, so a Japanese name from a century ago, what do you mean by that?
Yes, because it was registered during Japanese colonization of Korea in World War II.
Yeah.
After the war ended and Japanese people returned to Japan, my ancestors took possession of this land but never obtained formal certification. So, of course, this is a kind of exceptional case in in Korea. But generally, it is regarded as the transition from the regular certificate in writing to e-registration being successfully done.
I thought complexity sounds similar to some cases in Indonesia as well, although the causes might differ, don't you think? Now, Edgar, can you tell me what else do you think about Indonesia, whether Indonesia can develop further for its land practices in the future?
Sure. There are many areas for improvement. One clear example is the treatment of limited land rights, such as Hageu, Hagebe, and Hakbakai, etc. These rights are granted for a fixed period, and once the extension or renewal period ends, the land reverts to the state, country. Whether this is similar to the concept found in some other developing countries, it can be actually problematic, not only for justice, but also for Indonesia's economic development. So let's assume that there is a responsible and ethical modern company operating a plantation business in a remote area. This company employs lots of workers there, complies with CSR requirements, fulfills plasma obligations by collaborating with local farmers, build some local infrastructures like church, a mosque, hospital, etc., and even contributes through zakat. And I know many such exemplary companies in Indonesia. And now imagine their Hagebe, Hageu, Hakbakai expired, and they are forced to leave. Then the consequences will be devastating for that region and local area. Loss of jobs, economic stagnation, and the collapse of community support systems. So now let's imagine a scenario where these land rights expire on a large scale. Even 5 years before such an event, we are likely to see a significant decline in foreign investment into this sector, accompanied by growing concerns among stakeholders as well. So I think Indonesia needs a clear legal framework to protect bona fide business entities that contribute positively to the economy, local communities, and workers' welfare. The basic agrarian law, UPA, was enacted in 1960, which means it has been only over 60 years since its implementation. As such, Indonesia has not yet faced the large-scale exploration of these land rights, but this reality is approaching. It is coming now. So the country must proactively prepare for this scenario to ensure stability and continued growth.
Yeah, thank you so much, Edgar. That's a very valuable perspective coming from you. I'm also curious about the Indonesian lawyer's perspective on this matter.
Investors, we understand that they're requiring the legal certainty when they're investing in Indonesia. And in that sense, we believe that Indonesian governments need to provide the legal certainty to them in order to enhance the Indonesian investors' environment. In practice, we are still facing lots of problems here. And for example, like when there is a statute of limitation for the interested party to make a claim towards the landowner, in which it is stated in the regulations as 5 years, in practice, we still see many instances where the claim can still be processed even after the lapse of such 5 years. And in that case, it becomes a concern from the investors, particularly foreign investors who put lots of money in order to, long-term investment in Indonesia. They need certainty, and then we believe that improving the regulatory as well as on the enforcement would be essential in order to enhance the investment environment in Indonesia.
So I think from another perspective, to support the investment environment in Indonesia, establishing an online presence for all land offices in Indonesia is also important. While we acknowledge that some land offices already has an online presence, but often the officers on duty have differing opinions, and it actually complicates the legal certainties, like Bang Dani previously explained. And if this issue is addressed, I think this could accelerate transaction timeline, and then improve overall ease of doing business in Indonesia.
And in addition to that, we also see that the implementation of the electronic registration system, we see that this as an effort of the government in order to enhance the legal certainty by removing the possibilities, like, for example, the missing certificate while currently kept electronically. And we agree with the explanation previously from Edgar that we need time, and maybe in a decade, hopefully the government is already able to completely implement this electronic registration system and to eliminate issues related to this electronic registration system, such as the inconsistencies of information between the data contained in the electronic registration.
Well, that is all for today's episode. We hope this discussion gave you the valuable insights into the real estate law in Indonesia. And if you found this helpful, don't forget to follow our social media, as well as to follow our podcast and share it with others as well who might be interested in knowing more about other legal topics. And stay tuned for more conversation on various legal discussions as well. Until next time, everyone, and thanks for listening. Have a good day, everyone.